check.
So you switch shots back and forth between
Yes, I
one
do.
and two? Okay. And do
So-
you advise us to follow the switch or
No,
not?
just
No.
have a casual conversation.
Welcome to another episode of The Senior Focus. I'm here today with attorney John Rexford, and we're going to talk about elder law, issues that we face in our practice of elder law, and they're very important issues, and probably the cornerstone of what it is that we deal with is capacity, a person's ability to appreciate the consequences of their actions and what it is that they're doing. John, how are you?
Fine, thank you very much.
How long have you been an attorney?
About 27 years.
And what kind of things have you done during that 27 years?
I followed a path in the law that's just getting more and more focused on helping people that are in some way unable to help themselves.
So right now you're doing a lot of elder law, right?
Yes.
And when I say that, the cornerstone of what you do and what we do in the practice of elder law deals with capacity, would you say that there is accuracy in that statement?
Yes, I would. Yes, I would. It seems that for whatever reason, whether it's age or whether it's pathological disease, that when a person's mind becomes less functional, they need more help than most clients that I've worked with in the past.
And there is help for these people, but they have to be, or a loved one needs to be, whether we say proactive or reactive, they have to go out and they have to get that help. But the help is there for them if they choose it.
There's always help available, and I like the name of the firm with the word advocate in it, because advocate is really what attorneys are. And to advocate for someone is the ultimate form of helping them.
Let's step back and let's talk about you generally. Where do you live?
I live in Whitensville, just south of Millbury and Grafton, not too far from Worcester.
So it's central Massachusetts.
Yes, it is.
And are you married? Do you have children?
Yes, I've been happily married for 30 years, and I have 3 children that are real blessings.
And what about interests? What interests you? Do you have hobbies? What kind of things interest you?
Well, to be honest, I'm most interested in people, so I enjoy hobbies that deal with people or helping people. I'm involved in international missions work and also some missions work in Worcester. When I need a break from that, I enjoy reading a good book or being out on the water.
Well, I think that with respect to the work that you do at Elder and Disability Law Advocates, it really, plays into this interest you have in helping people, because that's what we do. That's what Elder and Disability Law Advocates does. They attempt to help people. Now, as the name implies, elder and disability, it's typically people that are over 60, 65 years of age, but in the event someone, like I said at the beginning of the program, needs assistance, we can help these people. When I say to you, what is your impression of elder and disability law advocates. If I were to say, what is elder and disability law advocates, how would you describe it to our viewers?
Well, first of all, I would describe it as a team. I don't think of it as one attorney. And I think of the team as including attorneys, office support, doctors, psychologists, social workers, and people in the community and government agencies. They might not all be at the law office, but they're all somehow connected to the function of helping someone. And at the law office, I just think of it as a smaller team that provides the legal documents and the legal procedures and the listening skills to discern what the need really is. And it's extremely exciting to be a part of it.
So, excuse me, your answer incorporates the idea that elder and disability law advocates is a law firm.
Yes.
A lot of people don't realize when they call, it's a law firm, and I'm not quite certain why they wouldn't get that, that distinction, because the name does say law advocates, but we provide not only personal needs planning, but also legal planning. When you think of elder law, if I were to say to you, what is elder law, how would you describe it?
Well, personally, I would describe it as using the law to assist people in a particular demographic segment of the population where age-related issues come up and the quality of life is the underlying goal. It's not always just a pure legal issue like incorporating a business or buying or selling something, but it's living. It's being able to function at home, being able to have a life where you have dignity and respect, and those issues can often be age-related.
You know, I got to say that I agree with you. My interpretation of what an elder law practice is it's a law firm, it's a firm that concentrates on quality of life issues rather than end of life issues. When the elderly would go and see an attorney before we'll say the advent of elder law, they went predominantly to address end of law issues. Now we do much more than address end of life issues. We address issues that affect a person's quality of life. And there are a number of different ways that can happen. As far as characteristics of an elder law practice, I think, like we've both said, focusing attention on quality of life issues. I also think this multidisciplinary perspective and approach and bringing to bear a number of different members of the team to help implement these quality of life issues for people, and also an integration of legal and personal needs planning. So when you say that you think of it as a team approach to be able to bring to bear those services that will help the senior population, I have to agree. I think that's specifically why Elder and Disability Law Advocates was created, to address the needs of the senior population and also individuals with disabilities. As far as the elements of an elder law practice, and specifically with elder and disability law advocates, what kind of issues or what kind of practice areas are predominant in elder and disability law advocates?
My view is there's a short list, maybe 4 or 5 practice areas. One would be estate planning, where if you haven't gotten your estate plan in order, it's a good chance to do so.
Right.
That meaning wills and trusts, powers of attorney, things like that, legal documents. The other would be just the issue of your capacity to function and make decisions. And if that's diminished enough, then legal help is available in the form of a guardianship or a conservatorship, which are closely related. The issue of having some assistance with the cost of long-term care is very common and frequent.
More important than ever at the moment.
Yes. And so that is always an open option to talk with clients about.
Are you aware that in Massachusetts there's a project called, I think it's called I'm not sure I can recall the precise title, but the Senior Economic Security Project, and it looks at a person's income and the ability of that senior and that senior's household to meet the financial needs, the expenses that would allow them to remain independent in the community. And Massachusetts ranks last of all the states in the senior's ability to pay those costs and to be able to remain in the community. So the idea of people needing proceeds, funds with which to meet long-term care takes on, I think, added significance.
I agree. I also am asked frequently the big magic question, will the nursing home take my house from me? And that is a big concern on people's minds. I take pleasure in trying to help resolve some of that concern, and not only through Medicaid eligibility, but the other programs that are available beyond just being in the nursing home,
Right.
that not everyone even knows about.
You know, everything is a result of planning. When a person procrastinates, takes that, I'll stick my head in the sand type approach, things deteriorate, health deteriorates, financial consequences occur, and what they most feared is probably what's going to happen. So a person really needs to address their situation, conduct whatever estate planning is necessary so that they can meet the look-back period for Mass Health. In the event they want assistance with meeting the needs of long-term care, again, they have to plan prospectively so that when they apply for benefits, if they need benefits and they so choose to do so, enough time has gone by where the conveyances and the transfers that they have made won't disqualify them from public benefits. A lot of people won't do it. It's a crisis-driven society. People seem to be penny-wise and pound-foolish, and they don't act until something terrible happens, and when they do so, it's kind of late. It's too late for them to get the benefits that they need.
I agree. I also find the people's image of lawyers can sometimes prevent them from getting the help they need. They think of lawyers as scary or intimidating or too expensive or will take away control from me, and I'd like to change that.
Right.
And have people see lawyers as helpers that will listen and that will help walk you through a situation, not tell you always what to do, but guide you through the path.
Yeah, the sad thing is that a lot of times people won't undertake the planning that's necessary just for the reasons that you indicated. And when they don't do so, in the event something happens to them, a medical situation unfolds, we'll say they operate under a crisis situation, the same very things that they were afraid of happening to them is likely to happen to them. Whereas if they planned prospectively, if they planned and they gave themselves enough berth, enough room between when they initiated the plan and when they needed to apply for benefits, enough time has gone by where they're able to receive public benefits.
Yeah, it's not always easy to plan ahead before the crisis hits.
Right.
When we hurt, that's when we want to go to the doctor. Doctors tell us, no, exercise, eat well, have preventative medicine. You can do the same with your legal issues too.
Right. The way I see it is, the worst thing that a person can do is procrastinate. You don't have to plan so that in the future, should things change, you've locked yourself in a box. But if there are certain things that you want to accomplish, you should plan for it. And for instance, a basic estate plan, power of attorney, healthcare proxy, and we'll talk more about these things in a moment, but they're very powerful and necessary documents. And when a person doesn't take into account their need to appoint, we'll say, surrogate decision makers for themselves in the event something happens, it really creates a very difficult environment for loved ones to operate under. And these are all the kind of things that elder and disability law advocates takes into account. Whether a person has the capacity and is able to execute documents, or we tend to see an awful lot of people who come in and perhaps they bring in a parent or a spouse who has been cognitively impaired and is no longer able to make decisions for themselves. That person is still, as you'd mentioned, able to receive some kind of assistance. It's not like they're out to lunch and they can't get help. They can get assistance as well. And like you said, whether it's from conservatorship, guardianship, there are ways to help these people. And what I'd like to do, we're going to have to head to a break in a moment, but when we come back on the other side of the break, I'd like to talk about some of the practice areas individually, separately, one by one, and perhaps give an example or two so that people understand the kind of work that you do at Elder and Disability Law Advocates. We'll be right back after these.
Millbury Healthcare Center is a highly respected 5-star, deficiency-free skilled nursing and rehabilitation center. We are renowned for our compassionate care and specialty programming, making it possible for your next step, returning home. We listen and take the time to understand your goals. We provide support and the tools needed to safely prepare for your transition home. Millbury Healthcare Center is the community choice for skilled nursing and rehabilitation.
Does your loved one suffer from memory impairment, dementia, or Alzheimer's disease? Consider Dodge Park Rest Home in Worcester. Our geriatric medical team and nursing staff are available 24 hours a day. We offer medication administration and incontinence care with dignity. Our activity programs are designed to engage and stimulate the mind. And with Dodge Park Rest Home, you can better protect your estate and save your assets with only a 1-year look back. Your loved one will feel safe and at home with Dodge Park Rest Home of Worcester.
Get a jump on summer. Charter Communications is a proud supporter of the Children's Friend Big Dipper All-You-Can-Eat Ice Cream Festival. Come on down to the Dipper on Saturday, June 30th at Worcester's Elm Park. What a better way to celebrate the start of summer than to indulge in the all-you-can-eat ice cream. And don't miss the fun and entertainment. Take a chance on some great raffle prizes. Get your face painted, jump on the moonwalks, try your hand at the speed pitch, and indulge yourself in the all-you-can-eat ice cream. For more information, visit childrensfriend.org.
Charter Business helps businesses achieve everyday victories. Want to be victorious today? Call 877-BIZ-BUNDLE and switch to Charter Business Internet and phone for just $99 a month. You'll enjoy internet 6 times faster than standard DSL, plus unlimited long distance. Getting a business bundle for just $99 a month makes for an easy decision. But hurry, because this offer won't last. So call 877-BIZ-BUNDLE today. To the victor go the spoils!
Join me on the Hank Stoltz Experience. People are always asking me, what is the experience? Well, that's the beauty of it. It's everything that has to do with Central Massachusetts. And just like Kelly Square, where the traffic never stops, we never stop either. There's no red lights on the Hank Stoltz Experience.
Charter TV3 and UMass Memorial Healthcare have teamed up to bring you the latest news and trends in healthcare. Health Watch, presented by UMass Memorial Healthcare, brings you the healthcare topics that are important to you. From stroke prevention to allergies, skincare to sports injury prevention, and nutrition to pregnancy, Health Watch and UMass Memorial Healthcare informed you on the issues that affect you on a daily basis. Health Watch on Charter TV3. For extended interviews with UMass Memorial Healthcare experts, log on to our website.
I'm Siobhan Connolly from Worcester News Tonight. Thank you for choosing Charter.
Welcome back to the Senior Focus. I'm your host, Nick Holtzis, and I'm here with attorney John Rexford, and we're going to talk, I think we're going to talk predominantly about capacity issues, really what we do everything we do touches on the issue of capacity. I do want to talk about certain practice issues that we're involved in, separately, individually, one at a time. So I thought right now we'd talk about estate planning. Now, one of the things that we frequently encounter and we oftentimes see is an individual, whether it's a spouse, whether it's an adult child that brings in a parent, will bring in someone who lacks capacity, who doesn't have the ability to enter into these legal documents. They want that done, but it can't be done. When I say to you, what do you think is the effect of a lack of capacity? What would you say?
Well, if you're asking about the effect of it, presuming that it exists, the effect of it is that as an attorney, you really can't allow that person to enter into some sort of legally binding or contractual document because they don't understand what they're agreeing to.
Right.
So you as an attorney have to be very, very careful. Sometimes you have to raise the invisible flag and say, let's stop.
Right. That happens rather frequently in our practice. People don't appreciate what it is that needs to be done, and we're uncomfortable proceeding because we have this issue of whether the person has the requisite legal capacity to execute these legal documents or not. Now, if I were to say, or someone were to say, what exactly is capacity? The way I might try to define it is, a person's ability to appreciate and understand the consequences of the legal document that they're about to enter into. Is that a definition that you would adopt as well, or would you say it a little differently?
I would say it the same way, and probably add a couple of more observations because it's such an important issue and not always easy to measure. But for example, the law will often ask, does the person have an awareness of what their estate is?
Right.
Can they articulate that? They don't have to rattle off their bank statements, but a general awareness. And do they have an awareness of who the natural objects of their affection would be as understood by the law? Do they understand their spouse, their children are contemplated as natural objects of their affection? You would presume, oh, that's a very easy thing, but not always.
Yeah, it's rather a sad situation because many times I have myself met with people and they'll know that they were brought to the office by that person that's sitting in that chair over there, but they won't know who that person is and what the name of that person is, and that person will be a spouse or a child, and they just won't know it. Now, when we talk about capacity, there are basically three separate types of capacity: legal capacity, the capacity to contract, and a testamentary capacity. And the items that you mentioned about, understanding and appreciating the nature of the instrument that you're about to sign and what the person's estate is comprised of. And we're not talking about a mathematical certainty of knowing to the penny how much money you have in the bank, or to the penny how much your annuity is worth, or what the cash value is of your life insurance. A lot of people won't be able to hazard a guess as to whether they even have a bank account or not. These are the people that need assistance, and we can provide assistance for them, and there is help that's available to these people. And we'll talk about that a little bit later in the show. One of the things I did want to talk about is the concept of undue influence. One of the things that we see rather frequently in the office is a person will execute a document, a will, some type of a testamentary document, and will be acting under the influence of some third party. Now, if you end up going into court and you want to contest a will, there are certain threshold matters that you have to reach. One is that, every will is going to be deemed and assumed to be valid unless someone objects to it. So there has to be an objection to the will. And in the event someone objects to the will, there's got to be a showing that satisfies the court that the person who executed this testamentary document was under the influence of some third party, was susceptible to their misrepresentations, and in fact acted as a result of those representations. But again, these are all issues that deal with someone who lacks capacity. I want to talk about the components of a basic estate plan. If someone comes in and they don't have capacity, can they execute an estate plan?
I would say no.
Okay. And if they come in and they have capacity, they understand what it is they want to do, they have an appreciation, for the estate planning documents and what they're going to do. They know who their children are and their spouse. They, have an understanding of, the objects of their bounty. They have an idea of, what their estate is comprised of. These people are able to plan so that, they're able to have a smooth transition from that point forward.
I agree. So long as the attorney can establish all those things in the person that's going to sign their name. Sometimes a client comes in with an adult child who does all the talking.
Right.
And the adult child says, Mom wants this, and Mom wants this, and Mom needs this. Will you do this for Mom? Mom hasn't said a word.
Right. That's a problem.
So it's careful to let Mom have the chance to talk.
Yeah, I think that what we want to do is, what is most effective, have a conversation with Mom. See what it is that Mom says. It's probably most effective if when Mom speaks and you're having a conversation with Mom, if Mom is your client, don't have anyone else in the room. The other person can wait in the reception area, in the waiting room. You can have your conversation with Mom and just make sure that you're satisfied that Mom has the requisite legal capacity to execute these documents that you're about to have her execute. Let's talk about a simple will. A lot of people call it an I love you will, a reciprocal will. When you hear a simple will, what do you think of?
When I hear of a simple will, what I think of, to be honest with you, is I think of the person writing a letter to the judge. Most clients think they're writing it to the kids. They don't understand that the will is going to be approved by the court before the kids can utilize it.
So it's the document that takes you to probate.
Correct.
A lot of people, a scary number of people, think they don't have to go to probate because they have a will. And then you have to explain to them, well, actually the will is a testamentary document, a probate document. It will lead you right into probate court. Doesn't take you away from court, takes you to the judge and to court.
I agree, and oftentimes I'll explain to a client that the nature of a will is similar to writing a letter to the judge, where you say, Dear Judge, if I'm no longer with us, these are my thoughts and wishes. I wish that you would honor them. And of course, usually the children are included, but it's a legal document that the judge will approve, which then gives the authority for action later on. It doesn't avoid the court. And the contents of the will, we allow the client to govern that.
So basically, it's a document that guides the distribution of assets in one's probate estate. Another differentiation that people seem to have a little confusion of is whether an asset is a probate asset and falls within the will, or is not a probate asset and the will has nothing to do about it. Can you tell us a little bit about what the distinctions are between a probate asset and a non-probate asset?
I'd be happy to. I like to use simple language, like the word stuck. That's a very simple language from my childhood. If someone passes away with assets left on this earth, sometimes there's access to those assets. They might be in a jointly held bank account, and so the joint owner has access. They might be a life insurance policy which has a designated beneficiary, so the beneficiary has access. If there's some legal access to the assets, then it will not be in the probate estate. But if there's not legal access, then we're stuck. There's an asset such as a bank account in the name of the deceased person, or stock certificates in the name of the deceased person, only in the name of the deceased person. No one else has authority to access those documents. Those stuck assets, as I jokingly call them, are in the probate.
Actually, that's a great way to explain it to people. If an individual passes away and has an asset that's jointly titled, of course there's access to that asset, so it doesn't fall within the probate estate because there's no need for the court to appoint a personal representative of the estate to gain access to that particular asset. Same thing will hold true with assets that are conveyed and transferred to a trust. The trustee of that trust is going to have access to that asset. So there are certain probate assets that need to go through the court system and have the court indicate, okay, I'm going to approve the petition for a will and appoint a personal representative of the estate, so then that person can gain access to those assets.
You know, it's so important, Nick. I agree with you so much. Many clients will say, my daughter's name is on the bank accounts as a matter of convenience or love or whatever, but not with the intention of estate planning. The same client will then say, I want to write a will and leave everything equally to my kids.
Right.
Not realizing that with your daughter's name on the bank account, you're giving her access before and after death.
Yeah, she has legal title to those assets.
And so those assets may not be subject to the will.
Right.
And that's so important to understand.
Yeah, and it's important to understand the mechanics of exactly how the estate is going to be distributed upon person's demise. And you know, if the person feels that, you know, it's okay for my daughter to have title, she's going to do exactly what I want, you know, from a legal point of view, I think that it's better to arrange the situation a little differently, or perhaps the person's name is on the account only for purposes of writing checks and so forth, but you know, for a matter of convenience, so those assets are actually in the probate estate so that it gets divided equally, you know, per the language in the will.
Absolutely.
Of course, these are all issues of when a person passes away and the distribution of their assets. But in the basic estate plan, and we're going to head to a break again, but before we do, I want to say that when we come back from the break, on the other side of the break, I'd like to talk about surrogate decision-making documents, the power of attorney, the healthcare proxy. Power of attorney is probably the most important document that an individual can have. And we're going to talk about those in detail on the other side of the break.
Great.
Does your loved one suffer from memory impairment, dementia, or Alzheimer's disease? Consider Dodge Park Rest Home in Worcester. Our geriatric medical team and nursing staff are available 24 hours a day. We offer medication administration and incontinence care with dignity. Our activity programs are designed to engage and stimulate the mind. And with Dodge Park Rest Home, you can better protect your estate and save your assets with only a 1-year look back. Your loved one will feel safe and at home with Dodge Park Rest Home of Worcester.
Millbury Healthcare Center is a highly respected 5-star deficiency-free skilled nursing and rehabilitation center. We are renowned for our compassionate care and specialty programming, making it possible for your next step, returning home. We listen and take the time to understand your goals. We provide support and the tools needed to safely prepare for your transition home. Millbury Healthcare Center is the community choice for skilled nursing and rehabilitation.
He's just a first-class citizen of Westboro High School. He's a first-class citizen of our team and of the town of Westboro. And
whether it's people involved in music, art, athletics, everybody loves Anna.
He's been like another coach in the field, definitely a great leader over the years.
She's a prime example of a self-motivated student.
She is motivated, she is driven, she strives for perfection.
She epitomizes all the good things that we expect from our young people.
Catch all the excitement with Dan Kenny and the Go Fish crew on Saturdays at 6 a.m. For more information about the show, go to www.gofishdan.com.
I'll take this just about any day.
Charter Business helps businesses achieve everyday victories. Want to be victorious today? Call 877-BIZ-BUNDLE. Switch to Charter Business and start saving over $50 a month. You'll enjoy internet 6 times faster than standard DSL, plus phone with unlimited long distance. Saving your business over $50 a month makes for an easy decision. It's indecision that'll cost you. So call 877-BIZ-BUNDLE today. To the victor go the spoils.
I'm Tom O'Donnell, Chief of Police for the town of West Brookfield, with an important safety message. Studies have proven that texting while driving is dangerous and has led to fatalities. Is taking your eyes off the road to read or respond to that text message worth the risk of getting into a car accident or worse? Be smart behind the wheel, not only for your safety, but the safety of others. This safe driving message is brought to you by the Central Massachusetts Chiefs of Police Association and Charter Communications.
I'm WTAG's Jordan Levy. Join me on the Jordan Levy Show weekday afternoons on Charter TV3. And thank you for choosing Charter.
Welcome back to the Senior Focus. I'm Nick Holtzis, your host, and I'm here with John Rexford. And I had indicated when we came back from the break we were going to talk about surrogate decision-making documents, and we're going to. But the one thing I did want to talk about is what happens if someone passes away with items in their name. They're the only ones who have access to those assets, and they don't have a will. They pass away intestate.
Well, the world out there will take the position that no one should touch the assets because they're in the name of someone who is not living. So to get authority over those assets, you have to go to the court system, which is the probate court. And many people say, well, but they don't have a will. In your hypothetical, they don't have a will. Mm-hmm. Well, that's true. Many people don't have a will. But you still have to go to probate court. You just go without the will. And you ask the judge for the authority that you need to get access, there's that word again, to the stuck assets, bank account or whatever it might be, even without a will. Well, then the question would be, once you've done that, how will the money be distributed? And it would be distributed under the laws of the Commonwealth of Massachusetts that would apply when no one has a will. And so there are laws that will step in and serve as a substitute will for those people that never got around to signing one.
So really, whether a person has a will or if a person passes away and doesn't have a will, the real issue is, as you put it, whether those assets are stuck and no one has access to those assets, and you have to go to court for a judge to appoint a representative of the estate so that person then has access to the assets.
That's right. The public often thinks going to court depends on a will, but it doesn't. It depends on access to the assets.
Okay. We're going to switch gears a little bit here and talk about a durable power of attorney. The difference between a power of attorney and a durable power of attorney?
Well, you know, the word durable is pretty easy to understand.
Yep.
So just like I'd like to buy a durable car. When the power of attorney is signed, it's a legal document that gives legal authority. And that authority is very, very useful when the signer loses capacity. That's when it's most useful.
Right.
So the word durable means it lasts for the duration of that need. Beyond diminished capacity, this document still works, is still legal, it doesn't stop, when capacity stops.
And on occasion, you'll see a document that's not a durable power of attorney, just a power of attorney. What if someone had a power of attorney, not durable, just a power of attorney, and then over the passage of time, they've lost the capacity, they're no longer competent? Is that power of attorney still valid or not?
I guess you could have to argue the point. They signed it, so we don't know what's going on in their mind. Do they still intend for it to be valid? The world will make the presumption that there's a question. And the question can be so strong that a bank might deny the document. They just might say, look, the person can't be consulted. It doesn't say that they want it to be durable, so we're not going to do business with you.
Yeah, as a matter of a legal principle, like you said, if it's a durable power of attorney, it lasts throughout the duration of an individual's need, even in the event they become incapacitated. That document, created by statute, gives authority to the agent to act on behalf of the principal. And if it's a power of attorney and there isn't that issue or that item of durability, so that in the event a person loses capacity, that document is no longer valid through the duration of an individual's incapacity, but loses effect upon incapacity. So, like I said, on occasion you'll see someone who, comes in with the power of attorney and thinks that they have the ability to make some decisions or conduct business on behalf of their principal. It might be a parent or a spouse. But if the document is not a durable power of attorney, they don't have that right. They don't have that ability to act on behalf of the person. In the event that person is no longer competent to act for themselves, the agent can act for that person either if it's not a durable power of attorney. So the fact that it's durable is tremendously important, at least in the line of work that we do. Typically as a person ages, the issue of cognitive decline becomes apparent, and the older an individual becomes, the more likely of cognitive decline. I've had people ask me, how often is it necessary to revisit the issue of estate planning documents? What would you say?
I would say it's driven mostly by life circumstances. So if you have a change of marital status, you have more children, you have stepchildren come into the picture, blended families suddenly appear, financial circumstances change drastically, you switch churches, you switch charitable interests. If your life circumstances shift around, that's a really, really good time to take another look at what you signed. Make sure that it's accurate. If you're just getting older, I don't think it's that crucial that you review it every year. I think it's more based on the circumstances, because the document doesn't change by itself. It's only your life that changes. The document should reflect what your life is.
Yeah, the way I try to explain it to people is that it's like when you purchase an automobile. When you first buy it, doesn't need to be maintained, doesn't need to be tuned, doesn't need oil or new spark plugs, doesn't need anything. It runs really well. It's a brand new vehicle. Over a period of time, if you haven't maintained and managed that vehicle, it begins to break down. And maybe 10 years, 15 years, 20 years down the road, it's likely to break down and leave you on the side of the road. Same thing with their estate planning documents. I'll agree wholeheartedly that there's no need for someone to have their estate planning documents revisited and examined and looked at and done every year. But you know what? It might be advantageous for someone to have their documents looked at every 4 years, every 5 years, something like that, so that they're certain that in the event of a life change, those things that have happened don't alter the desires of the person, so that in the event they want, like in a power of attorney, they want their son Joey to provide agency for them and to make decisions for them in the event they're not able to do so, that a number of years haven't gone by and they no longer want that relationship. Instead, they'd rather have it with a daughter that they have or with another son. So I think it's important that over a period of time, maybe 5 years or so, at least take a look at the documents. I know there is nothing in the law that indicates, hey, the documents are stale, they lose their effect after a period of years. I know that it doesn't say that. But can you imagine what it would be like if a person were to rely on power of attorney only to find out that, hey, this document is doing what I wanted to do 10 years ago, but the person that I've named as an agent is no longer here. They've predeceased me, and there's no one in the power of attorney to act on behalf of the principal. Right. The other item that we're going to talk about, healthcare proxy, a lot like a power of attorney. Power of attorneys, specifically for financial decision-making purposes. On occasion, you might see a power of attorney that indicates that the agent under that document has the right, the power over certain healthcare decisions, predominantly to get the information. But I think in Massachusetts, that's predominantly the domain of the healthcare proxy. And we're going to talk about, the similarities in those two documents, the durable power of attorney and the healthcare proxy. But when we come back from the break, on the other side of the break, not only do I want to compare those documents, but I also want to talk about a trust-based estate plan, and an estate plan that is a little bit more involved than a simple estate plan. So we'll be back with more Senior Focus right after this message.
Millbury Healthcare Center is a highly respected 5-star deficiency-free skilled nursing and rehabilitation center. We are renowned for our compassionate care and specialty programming, making it possible for your next step, returning home. We listen and take the time to understand your goals. We provide support and the tools needed to safely prepare for your transition home. Millbury Healthcare Center is the community choice for skilled nursing and rehabilitation.
Does your loved one suffer from memory impairment, dementia, or Alzheimer's disease? Consider Dodge Park Rest Home in Worcester. Our geriatric medical team and nursing staff are available 24 hours a day. We offer medication administration and incontinence care with dignity. Our activity programs are designed to engage and stimulate the mind. And with Dodge Park Rest Home, you can better protect your estate and save your assets with only a 1-year look back. Your loved one will feel safe and at home with Dodge Park Rest Home of Worcester.
Tired of weather reports that don't focus on Central Mass? Introducing Worcester Weather, the only video weather report for Worcester. Worcester Weather is easily accessible 24/7 by visiting chartertv3.com. It is updated throughout the day to give you the best video forecast possible. Worcester Weather also airs at 5 p.m. during the Jordan Levy Show and every Worcester News Tonight telecast. Worcester Weather gives you the local forecast you have always wanted. Worcester Weather on Charter TV3 and chartertv3.com. Brought to you by Berterra Nissan of Auburn.
Reintegrate former prisoners into society.
But both sides will see higher tax bills moving forward. The child's injuries were severe and determined to be inflicted.
The goal here is to keep the sulfuric acid from spreading any further.
Charter Business helps businesses achieve everyday victories. Want to be victorious today? Pick up the phone, switch to Charter Business, and start saving over $50 a month. You'll enjoy internet 6 times faster than standard DSL. Plus, business phone with unlimited long distance. If saving over $50 a month doesn't make your decision easy, this will. Call now and get up to a $500 gift card. But hurry, because this offer won't last. To the victor go the spoils!
Charter TV3 and UMass Memorial Healthcare have teamed up to bring you the latest news and trends in healthcare. Health Watch, presented by UMass Memorial Healthcare, brings you the healthcare topics that are important to you. From stroke prevention to allergies, skincare to sports injury prevention, and nutrition to pregnancy, Health Watch at UMass Memorial Healthcare informs you on the issues that affect you on a daily basis. Health Watch on Charter TV3. For extended interviews with UMass Memorial Healthcare experts, log on to our website.
I'm Kristen Doucette from Worcester News Tonight. Thank you for choosing Charter.
Welcome back to the Senior Focus. Once again, I'm your host, Nick Kalsis, and I'm here with John Rexford, an attorney at Elder and Disability Law Advocates, and we were talking about basic estate planning and capacity issues, and as I said before, capacity touches everything we do, whether it's the adoption and creation of the basic estate plan or even just the power of attorney. If someone doesn't have capacity, they're not going to get a power of attorney drafted and executed at Elder and Disability Law Advocates. Is that right?
That's right. We suggest they come in before that happens.
Yeah, it's of extreme importance that you develop a level of comfort with the person that is going to execute that document so that you know that the person has the ability to execute these documents. Lots of times we get calls from, children whose parents are in nursing homes or assisted living facilities, and they would like for us to go there and execute documents. And, I guess it's kind of like when your physician treated you when you were a kid. Yeah, we'll make house visits. There'll be house visits that are made by Elder and Disability Law Advocates. But, again, of paramount importance is the person's ability to comprehend what they're doing, their capacity. Because even if you make a home visit, if you made a home visit and you got there and the person didn't have the ability, didn't have the capacity to execute those documents, what are you going to
do? Politely and respectfully not allow the documents to be signed.
Yeah, you're going to politely turn and walk out is what you're going to do.
Ultimately, yes.
So it's really important that, the lawyer, whether it's Elder and Disability Law Advocates that provides the lawyer or some other particular lawyer that's doing the work, the law says the person has to have the requisite level of capacity necessary to execute legal documents. So even if you find an attorney that is willing to make the house call, kind of make sure that, your loved one, your spouse, your parent, whatever, has the requisite capacity to do so, to enter into that legal document, because, just speaking from the perspective of Elder and Disability Law Advocates, and probably many, if not all law firms out there as well, in the event the lawyer gets to the house and sees that the person lacks the capacity to execute the document, that document's not getting executed. I wanted to talk about and compare a power of attorney and a healthcare proxy. They're really almost virtually identical documents.
Right.
They're both guided by the laws of agency. They both create a principal and an agent. The agent is the person that the principal, the person who creates the document, nominates and appoints as the person to make decisions for them in the event of incapacity. Now, with the durable power of attorney, as you know, it can be an immediate power of attorney or it can be a springing power of attorney. And a lot of people will ask me, well, when you say springing power of attorney, what do you mean by that? Do you know what I mean by that?
Well, I believe so. I believe that it reminds me when I was a child and I had a Jack-in-the-Box toy where you turn the little crank and then the puppet pops out of the box.
Mm-hmm.
It springs up on a spring. In a springing power of attorney, the document is closed. The box is closed and it's not usable until a certain event happens to spring the clown out. So the document says, you can't use me until this happens, then I spring into action. The legal authority springs up from the event, which is usually diminished capacity.
John, I gotta say, I love the descriptions that you give. That's precisely the way I would describe a spring power of attorney. I might not describe it as eloquently as you just did, but it is like a jack in the box, and you have the crank. And until that jack in the box springs into action, the document itself is not effective. The appointment is not valid. It creates the necessity for a condition to occur, like you said, predominantly it will be the incapacity of the principal before the effect of the document, before the document becomes effective. Now, with the durable power of attorney, like I said, it can either be immediate, so that there is effect, it is an effective document upon signature. Whether there are two witnesses, whether it's notarized, which is things that I believe Elder and Disability Law Advocates does, is two witnesses and a notary, and it is immediately effective, or a springing power, where you might say something like, but for my incapacity to be established by my primary care treating physician and a physician specializing in the field causing my disability, this document is dormant and the agent doesn't have authority to act on my behalf until my incapacity. That's a springing document. The healthcare proxy is by law, by statute, a springing document. If a person has the ability to communicate with the healthcare provider and indicate what it is they would like to see happen and what it is, what treatment they want, is the healthcare proxy valid?
No, not at all. The box hasn't opened. If you can make your own medical decisions, the puppet stays in the box. You make your own decisions.
A lot of people will say, well, I don't want to execute a healthcare proxy because I want to be able to make the decisions for myself. And if I appoint another person to act for me, that decision is going to get taken right away from me, and I'm not going to be able to make that decision. That's not true, is it?
No, people need to be reassured that whether it's a power of attorney or a healthcare proxy, you're not giving up your own decision-making ability. You're just lining up help for when help is needed. But after the documents leave the office, you can still go into the life that you were living and make your own decisions. You haven't given up anything. You just added an extra layer of help for when that day is needed.
And it's a great protection to have, so that in the event a person is not able to communicate intelligently with their healthcare providers, and the healthcare provider needs to make a decision on what kind of treatment needs to be rendered, there is someone who can step into the shoes of the patient and indicate what decisions the patient would want made.
That's right. I have had the experience in the hospital where the medical staff would make a decision. Is this healthcare proxy invoked? Is it engaged? Or do we still allow the patient in the bed to make their own decisions? They will painstakingly allow the patient in the bed to make their own decisions, if possible.
Right.
Only if that's not possible do they make a check on the chart that the healthcare proxy is now going to take over. It's almost a last resort.
And what happens if a person suffers some kind of a cognitive issue, a cognitive decline, is not able to render decisions or give informed consent to medical provider? The medical provider invokes the healthcare proxy. So when they invoke the healthcare proxy, okay, now it's an effective document, and they're going to go to the healthcare proxy and get information or decisions from the agent. What if that person then regains capacity and is able to make their own decisions again?
Well, I like to point out to the viewers of the show, Nick, that everything you're talking about goes back to capacity. If you're in the hospital and you lose capacity, the healthcare proxy is invoked, someone else makes decisions for you. But if you regain capacity, and it's always about capacity, you can sit up in the bed and say, I revoke that healthcare proxy, I can make my own decisions now, I'm feeling much better, please listen to me, I want to make my own decisions. The medical staff will do that. They'll shift back and let you be the decision maker.
You know, this is all such important information for people to hear, to understand. There's so much. We basically just scratched the tip of the iceberg, whether we wanted to talk about trusts, guardianships, conservatorships, estate administration. I'm afraid we've run out of time. I want to thank you for coming in and talking about these very important issues. And I want to thank all of our viewers for watching this episode of the Senior Focus, and I'll see you next week.
Great.